is not financial advice. This is not legal advice. This is for educational, entertainment purposes only. And everything I say is my opinion. Please hit the like button, the subscribe button, and the notification button so you can get all my updates on the stock market, all my updates on the lawsuit. This morning, I filed a notice of appeal to the Court of Appeals from the case in Florida because there's been a lot of shenanigans going on inside the courtroom. They've been doing things that are contrary to the law, and the courts have been allowing them to get away with it. So I felt my only course of action was to appeal it to the Court of Appeals, the 11th Circuit Court rather, in Atlanta, Georgia. Now, the real purpose of this video, because I'd like your opinions on what's going on. And you don't have to be a legal scholar, you don't have to have graduated law school to understand the nonsense that the courts are allowing Citadel and Ken Griffin to play inside the federal courtroom. Now, the purpose of this video is to find out, does Citadel own our courts? And the reason I'm asking that question is, first of all, they closed the class action lawsuit against Citadel even though there was overwhelming evidence that there was collusion with the buy button fiasco in January. And the thing is, after additional research by the aides, additional research by the retail investors, there's speculation that the judge that granted the dismissal of the class action lawsuit was a spouse of one of the attorneys for the defendants. In any other case, she would have to recuse herself because of a conflict of interest. And there's also speculation that she was personally handpicked by a buddy of Ken Griffin to be assigned that case. So that's another conflict of interest that needs to be further investigated as far as I'm concerned. Okay, now here's where we are with the lawsuit that I filed. Okay, the judge requested, or ordered rather, that I do a joint scheduling report. Now, here's where the shenanigans start. Here's where the nonsense starts. A regular joint scheduling order is usually 60 days from the day the defendant responds, or 90 days from the date that you serve the first person. Instead of giving me the 90 days after I serve the first person, the judge cut it down to 60 days. Okay, the judge cut it down to 60 days. That means I gotta work a little faster. I gotta work. I'm under pressure now. I'm under time constraints. So what I do, I put it together. I email the defendant's attorneys, Ken Griffin, Citadel, DTCC, Robinhood, and I explain to them that I'm ready. Let's get this joint scheduling order together. The defendants refused to participate in preparing the joint scheduling report. So I'm like, why would they refuse the joint scheduling report? Then, because they refused the joint scheduling report, the judge then says that until we submit the joint scheduling report, the case cannot move forward. He cannot make a decision on a preliminary injunction for a fair and accurate share count of AMC and GME until he gets a joint scheduling order. So the defendants are refusing to participate in doing a joint scheduling order, so therefore the case is in limbo. The case cannot move forward. So what I do is I file a motion with the courts asking the court to order the defendants, Ken Griffin, Citadel, DTCC, order them to participate with me in preparing the joint scheduling report so the case could move forward. The judge denies my request. Now, I want you to understand what's going on here. The judge is saying, understand this circle. The judge is saying the case can't move forward until the joint scheduling report is done. I am ready and willing to do the joint scheduling report. The defendants are saying they're not going to do it until the SEC is served. They're using the fact that I hadn't served the SEC, and the SEC has been ducking me for service. They've been ducking me. When I sent a process server over to the SEC address in Washington, D.C., what they were doing is having a security guard tell my process server that they're not allowed to accept service at the front desk. But anyway, I got around that. I got a more aggressive process server, and he eventually got the SEC served. But now that the SEC is served, the defendants now are now saying that the SEC wasn't served properly, and because the SEC wasn't served properly, that's now the other reason why they're not going to participate in preparing the joint scheduling order. Now, I want you to understand this. Once again, I filed a motion with the district court, and I tell the district court, I served the SEC, Ken Griffin, Citadel, DTCC, Robinhood don't have any standing to contest the service of the SEC. They have none. They don't represent the SEC. The only person with standing to contest the service to the SEC is the SEC. So the other thing is, I'm going to explain this rule to you. It's Rule 26D. And this rules deal with when you have parties that are served in the lawsuit after the lawsuit's already filed, or after the lawsuit's already ongoing. Now, listen carefully what this rule says. Rule 26D, time for initial disclosures for parties served or joined later, which means when you initially file a lawsuit, you might have some parties that you can serve right away, or you might have some parties that waive service. Or when these parties waive service, then they're in a lawsuit, and you might have parties that you have to get real aggressive with the service because they're hiding, they're ducking, they don't want to be served. But what it says, a party that is first served or otherwise joined after the Rule 26F conference must make the initial disclosures within 30 days after being served or joined, unless a different time is set by stipulation or court order. So there is a rule in place that allows them to participate in a joint scheduling order, and later on, after the SEC is served, then we can do an amended joint scheduling report to submit to the courts. So once again, I filed a motion with the courts, asking the courts to obligate these guys, the defendants, Citadel, Ken Griffin, to participate in preparing the joint scheduling report, and the judge once again denied my motion. Now, how can this even make any sense? So what I did was, I prepared a joint scheduling report on my own, I signed it on my own, and I submitted it to the court. And then you know what the court did? The court tells me, well, because none of the defendants signed the joint scheduling order, he's not going to accept it. So let's get this clear. In order for the case to move forward, we need a joint scheduling order. The defendants refuse to participate in the joint scheduling order. I don't refuse, and I prepare a joint scheduling order and submit it to the courts, and I ask the courts to order the defendants to participate in the joint scheduling order, and the courts deny me that motion. Yet they're saying until they sign it, the lawsuit can't move forward. So at this point, what was my only course of action? I went out to the court this morning, I filed a notice of appeal, and now we're going to be in the Court of Appeals. And if this has to go all the way to the Supreme Court, it'll go to the Supreme Court, because I am not afraid to fight for what I know is right. I'm not, and I am very committed to what we're doing. I am very committed to what we're doing, and I'm reading the law. If they felt that they could win this case on the merits of the case, they wouldn't be playing these games. And the fact that the courts is allowing them to get away with it makes me wonder, does Citadel own our courts? Anyway, I would like, please leave some comments. I'd like to know what y'all think about this. Subscribe, hit the like button. Have a great day.